hit COVID-19. And so now we're looking at a lot of lease renegotiations, and we're going to talk about that today, and non-payment of rent. And then if things really don't work out, how do you go through a bankruptcy and deal, whether you're the tenant or the landlord, how do you deal with that? And Richard here is to explain some of the things. So it's kind of a whole new world with this COVID-19, and give you some statistics. San Francisco Apartment Association did a survey of their members last month. 97% of residential tenants paid rent, which is great. 57% of commercial tenants did not pay rent last month in San Francisco. So this creates very unique challenges. And today we're going to talk about the commercial side. I know there's a lot of information on the residential side, but today we're going to talk about commercial. So what happens when that tenant can't pay rent? How can you renegotiate? How can you go through the bankruptcy process and still try to keep your employees and not crash along with the process? So with that, I'd like to start off with Myra. I know, Myra, you have your PowerPoint, and then I have a few things to say. There's a couple state bills that we're looking at, and then Richard will go to you, and then we'll go to a Q&A. So that's kind of how we're doing that today. So Myra, go ahead and launch your PowerPoint presentation.
Share my screen here. Oh, hang on a second. Share screen. I'm trying to find which one it is.
So while you're doing that, the feedback I've gotten from the marketplace is a friend of mine has an automotive tenant, Big O Tires, and they've received letters that they're not paying rent for 3 months. And this is a single tenant building, and this is hard on a lot of people. It seems like a lot of smaller tenants are paying rent, a lot of larger tenants are not. So with that said, Myra, kick off here.
Can you see the PowerPoint?
I can, yes.
Great, great. And as I'm looking at myself, good morning, everybody, first of all. And I wish I could say you're looking at my shelter-in-place hair, but that's how I always look. So is somebody going to be timing me for 10 minutes, or should I put on a timer?
You can put on a timer.
Why don't I go ahead?
I'll send you.
Okay, let me know.
Yeah.
Okay, so as Steve said, I'm going to be focusing on the commercial side, not talking about residential or multifamily today. And I'm looking at things more from a landlord standpoint. What do you do when, if you're lucky enough that your tenant comes to you and says, hey, I'm in a bind, I need some relief, or worse yet, they just go dark and they stop paying. And most of the time, let me take a step back. I want to just focus for a minute on the shifting dynamic between landlords and tenants during this crisis, a couple of different approaches you can take to lease modification, the short and the long term, and then a few legal and lending considerations that landlords should keep always in the back of their minds before they commit to anything firm. Okay, so the first analysis, clients come to me and they say, hey, my tenant's not paying rent. Look at this email I got. They want to, defer rent for 4, 5, 6 months. What should I do? What does my lease say? And normally the analysis is so simple because leases favor landlords so much in making payment of rent sacrosanct, without offset deduction, for no excuse. And if there happens to be a force majeure clause in the lease, it probably won't even mention pandemic, but even if it does, it'll probably say that notwithstanding any force majeure event, the tenant still has to pay rent. So leases do not favor tenants. And landlords, though, are going to be very disappointed to learn that in this climate, probably none of that really matters. We all have to shift our thinking, because by taking a hard line with tenants, you may very well put them out of business, and they may not be so easy to replace. And even if you can replace them, you may find that, the rent you thought you could get, or that you could even get 6 months ago, you're not going to be getting in the 6 months to come. So it really behooves everybody, I think now more than ever, to take a really practical and pragmatic approach to what's going on. I always advise pragmatism and practicality over, strict looking at lease language. But even in the best days, landlords have to spend money and have vacancy and legal time and all of the hassle and expense that goes along with getting tenants out or collecting rent. And now all of that is magnified and heightened because of the patchwork of moratoriums that are around the state. the fact that courts have been closed, and once they reopen, take a number. So, my advice to landlords is let's try and preserve the tenancies that you have and try to make things work. Now, one thing that often comes into play with the landlords is, well, what about PPP under the CARES Act? Shouldn't the tenants apply for that and use the money to pay me? And yes, that may seem fair and reasonable, but there's nothing in the PPP or the CARES Act that requires tenants to use that money to pay the landlord. It's mainly geared for payroll. And if you, as a tenant, choose not to apply it toward rent and forego some of the forgiveness as a pragmatic business decision, there isn't really a whole lot the landlord can do about that. I have a couple of tenant clients, for example, who are very put off by the fact that the landlord refused to talk turkey at all until they saw their PPP application, until they got a commitment that the tenant would pay the PPP money toward the rent, because the tenant's looking long-term, both in terms of wanting to keep their employees on board, but, for example, have cash flow to jump on getting inventory, to get back in the game when things reopen. Their feeling is, well, there's not much the landlord can do to touch me right now anyway. I'll just take my chances for 3 months, and then however long after that it takes for the landlord to come after me and not pay my PPP money toward the rent. So landlords may find that frustrating, but I think that's an unfortunate reality of the times that we're in. So let's assume that both parties are on board and want to talk about what really amounts to a Band-Aid just to get through a very uncertain short-term time, to get to the other end of the tunnel and see what's going to happen in September, October. There's a few different approaches. Some tenants are coming to the table just wanting basically a rent reduction, somewhat long-term. And landlords will typically push back hard on that and say, no. I'll get you through April, May, June, maybe July, but we're not going to commit to anything beyond that. So I, in my practice, have not seen many lease workouts that involve a long-term reduction. What I am seeing is abatements and deferrals. And abatements, take the form of where the landlord is actually willing to eat some or all of the rent. I've seen some full abatements for a period of months. I've seen half abatements. I've seen abatements that include operating expenses as well as those that don't. And the key thing for landlords is twofold. Is number one, tenant, prove you need it. Prove that either you've been shut down, unable to operate, lost revenues. Because keep in mind, some office tenants, even though they haven't been able to come into the office, they're actually doing just fine working remotely. The hardest hit sectors have been retail and restaurant and, all those catering, those types of businesses. So landlords also want to know, when is this going to end? And are you going to be able to resume paying rent once it does end? The deferral approach, I find more landlords like this, where they'll defer some rent, whether it be 100%, 50%, or some variation on that, but then they want it either tagged onto the rent payment once things reopen and the tenants are back in business, or I've seen where landlords will just provide a fixed due date, pay it however, whenever, as and when you can, as long as you get it paid at the end of the day. I'm not seeing a lot of landlords demanding interest on this money. They seem to understand that, don't push your luck, be glad if you get the rent paid back at all. But in all cases, I think it behooves landlords to get the backup documentation, get some proof of business loss before you agree to rent relief. I think it's very important, and I say this not just because I'm a lawyer, but I guess in part because I am, that if you're going to agree to something, get it in writing. It can be a very simple lease amendment. They typically run just a couple of pages. I've been doing them at a discount rate just to kind of help people through the crisis. But don't rely on the emails or the phone calls. There's so many nuances. For example, did you agree to an abatement or did you agree to a deferral? Is it payable with the rent when it starts again, or is it not payable till the end? There's all these things that really need to be pinned down. And another thing where people will argue is, well, what does rent abatement mean? And do I still have to pay CAM? Do I still have to pay operating expenses? And the other thing to think about and to incorporate in your agreement is, how does this temporary relief interplay with the balance of the lease? So in other words, if the tenant starts committing other lease defaults, like letting their insurance lapse, for example, or not reporting their sales if they're a retail business, does that mean all bets are off on the rent deal, or are landlords forced to overlook that? I think that should be addressed. Another thing, since the market is so spotty and it's so uncertain that tenants are going to be able to open up again, you want to make sure that if they assign or sublease, that this sweet deal you gave them doesn't track on to the assignee or subtenant. I see I really have to plow through because I'm running out of time. So let me just say a few quick words about the long-term approach. Some parties are really trying to make lemonade out of these lemons and try and, for example, get the tenant to commit to exercise a renewal option ahead of time, so you have certainty as the landlord what their intentions are. Or landlords are trying to extend and tag time on the end so they can recoup some of the abatement rent that they granted. Now would be a good time, if you've been uncertain about your tenant's creditworthiness, to get a corporate guarantee. If you have a retail tenant who hasn't been paying percentage rent, might be a good time to introduce that so you get some of the upside if and when there ever is upside again. And then there's the unfortunate situation where a tenant's just been a bad tenant all along, and this may be the opportunity to open up discussions about just terminating the lease and getting the space back. I'm going to skip over all of this. I'm going to be very curious to see as and when landlords get back into litigating mode, what defenses tenants raise and how they fare. The problem with most of the defenses, in my opinion, is that, like impossibility of performance and, breach of laws and all of that, they're all short-term issues. And that doesn't, to me, render the entire lease non-viable. But I'll be interested to see if courts agree with me. Last thing really quickly, a lot of my landlords clients are finding a frustration of getting tenants across the finish line after the deal has been agreed with in principle. It's almost like they're just taking a wait and see attitude to see what legislation comes down the pike. They're hedging their bets on the state bailing them out better than the landlord, and Steve will talk about that a little bit. But there are a few levers that landlords can impose, like, for example, if there's a renewal option that the tenant wants to preserve, look at that language. Many times, even a past default can invalidate that. Same goes for lease inducements, like a TI allowance or free rent at the beginning of the term. That might have been dependent on pristine performance all throughout the lease term. And this could be an opportunity to bring that back on the table and say, hey, you're in default right now, and if we don't clean this up, then those things, you're going to be liable for them. Be careful with the late fees and interest and all of that. A lot of the moratoria don't allow for that right now, and you don't want to be in violation of those. Last but not least, keep your lender in the loop. Unfortunately, the state relief has focused on tenants, and it hasn't given landlords concurrent relief with their lenders. A lot of loan agreements say you have to check with your lender, especially if it's a major tenant, before doing an amendment. And any admission that you are, as a landlord, are going to be unable to make your mortgage payment could possibly activate those bad boy carve-outs in your loan. So you want to be communicative, but you want to be careful and keep that in mind as far as how you strategize what you're going to do with your tenants. So the bottom line for my talk, the takeaway is I think the pendulum for the short term is swinging in favor of tenants just because of the emergency situation we're in. And I think if you can cut a deal with your tenant that'll work for everybody, you're better off than trying to go to war over rent relief. Thank you.
Thank you, Myra. That was great.
Now, how do I take my screen off?
Well, so Richard, let's go to you. I help her and I bring my screen up. So why don't you give us some feedback on some of the bankruptcies and workouts you're seeing on your end?
Sure. Well, let's say that you don't take Myra's advice and you get to an impasse with your tenant. One of the things the tenant can do is file bankruptcy. Usually the first goal of the tenant is to invoke what is called the automatic stay. which in bankruptcy basically stops all litigation, stops all foreclosure, all actions against the debtor or the debtor's property. Generally, there's two forms of bankruptcy applicable to commercial tenants. Chapter 7 is they just go in and they turn over their assets to a trustee who then liquidates it. Typically, there's no action with respect to the lease of the real property other than to reject it. And then the landlord needs to focus on it, on the landlord's claim, which I'll come to later. The real action is in a Chapter 11 where, let's say, a chain of retail stores files for bankruptcy, and their goal is to try to shed some stores but preserve others and continue on in business. So the first thing you need to know is that a commercial tenant in bankruptcy has a duty to pay rent currently. He must timely perform all obligations under the lease from and after the date the case is filed. A landlord would need to be proactive to make sure that that's happening, because if it doesn't, you lose certain priorities down the road. It'll always be, there's two kinds of claims in bankruptcy. There is the administrative claim, which is the cost of the bankruptcy process, which it covers all the lawyers and all of the expenses incurred after the petition is filed. All the other problems and claims are unsecured claims. And generally, you don't want to be an unsecured claim because they're typically paid pennies on the dollar, if anything. But and sometimes, claims can be valuable depending upon how successful the store can be coming out. So the debtor has basically, can get an extension in terms of the timing to pay the rent, but only until day 60. By then, the court cannot grant further extensions and has to order them to pay. And if they don't, you can seek the conversion of the case and the termination of the debtor's bankruptcy. I know that in state outside of bankruptcy, a landlord is often reluctant to accept rent in certain circumstances where you think that doing so would cause a problem for one of your defenses or one of your positions. But the bankruptcy code expressly states that any acceptance of rent in a bankruptcy does not constitute a waiver or relinquishment of the lessor's rights under such lease. So that's a helpful provision. Okay, so now the debtor is in there paying rent. What is the debtor's plan? Well, one thing they might try to do is to assume the good leases. So let's say your lease is one of the ones that's valuable to the business. They want to assume it. Normally, in order to assume a lease, they have to cure, the lessee has to cure all pre-petition defaults, all monetary defaults. Now, if there's a provision in the lease that says that the store can't go dark for any particular period of time, they don't have to cure that. That's an uncurable concept, and they can assume the lease, without curing that. They cannot assume the lease if the lease has been terminated under state law before the bankruptcy begins. And there's a landmark case called In Re Windmill Farms. I'll never forget it because I used to shop there in college. The rule is that if there is a 3-day notice to pay rent or quit, and the lessee fails to pay the rent in default within the 3-day period, and further, provided that the lessor's notice contained an election to declare the lease forfeited, then it's over for the tenant. They cannot assume the lease. Now, if they do want to assume the lease and cure it, all further rent payments are administrative obligations. They have to be paid 100 cents on the dollar in the bankruptcy ahead of everybody else. So that's a good place to be, provided you like the tenant. So that's, there's one other element to this, and that is in shopping centers, there's a provision that the debtor can assume and also assign the lease to a new tenant And in certain, if there are mixes, requirements for the shopping center that you can't have two nail salons right next to each other and so on, bankruptcy law respects that. That only really comes into play, however, and when the tenant has a really below market lease. And I don't think there are any such thing right now as a below market lease. Everything is probably above market, so to speak. Okay, so now you want to figure out how am I going to recover all this past rent that the debtor owes. Oh, I guess I should address the other. If the debtor decides not to assume the lease, then the alternative is the debtor rejects the lease. And rejection of a lease simply means that the lease is deemed to have been breached as of the minute before the bankruptcy case is filed, and all the consequent damages from that are unsecured claims. Let's say you now are thinking about, okay, I have a claim here. The lease has been terminated. It was supposed to run for 10 years. There's a lot of future damages here. What are the rules? Well, one of the rules is that there is a cap on the damages that a landlord can recover in bankruptcy. And it's measured by two factors. One is it's the maximum is 1 year of rent or 15%, whichever is greater, but not to exceed 3 years of rent. So if you've got a 10-year lease, you have damages for the next 9 years, you can only recover for either 1 year's worth of rent or up to 3 years rent based on this 15% formula. That's called the cap. And the cap is measured in time from when the lease was either repossessed, the premises were repossessed, the lease was surrendered, or the date of the petition. And there are lots of, if the amounts are close, if you think you're going to be in a situation where you're really close to the edge, you want to not take a surrender of the property so that you can get a larger recovery.
Hey, Richard,
Yes.
Is Steve. So in a minute or so, what is the main takeaway that people should know about the bankruptcy provision?
Well, the main takeaway is that you often need to look to other sources, which was going to be my final point. Guarantors. And guarantors are not protected by a bankruptcy. They're not protected by the automatic stay. They have to step in and pay. However, their obligation is no greater than that of the debtor. So for example, if the debtor is unable to invoke the cap and only pay 1 year's worth of rent, the guarantor gets the benefit of that, even though outside of bankruptcy, the guarantor would have been on the hook for the entire 9 years. The other aspect of this is letters of credit. Letters of credit are great. They work as a form of security deposit. And if the tenant files for bankruptcy, the automatic stay does not prohibit calling or drawing on the letter of credit. It's deemed to be completely separate, a separate obligation of the bank. And so the landlord can look to the letter of credit. However, again, the amount that the letter of credit will cover is capped at this 15% or 1 year formula. Having said that, in rare case, well, the reason that it's capped is because when the tenant got the letter of credit, the tenant gave the bank a security interest in a pile of cash. And so it's treated like the debtor's loss in that situation. So those are the big points.
Okay, great. So we're going to go into some legislative stuff, and then we'll go into Q&A and ask your questions. Please put your questions in the Q&A, and I'll read them off, and we'll have the panelists answer. So at this point, let's talk about some of the legislative stuff that's kind of in the works here. Okay. Everybody see the screen? All right, so There's some governor's executive orders, judicial council, and there's one main piece of legislation, SB 939, that we'll talk about. There's been some updates to that piece of legislation. All right, so we tried to explain this in a chart. So the governor issued an executive order basically suspending 1161 of the California Civil Code, and it allowed local jurisdictions to create eviction moratoriums. And I'm going to use an example here in Oakland. They put a residential and a commercial moratorium in place until May 31st. And then it got extended with another executive order for another 60 days. So if you're going to do a commercial eviction, check your local ordinance. Make sure that there's not a prohibition at the local level. The other thing that I wanted to chat about is the judicial council. It suspends the issuance of summons and all unlawful detainer complaints until 90 days after the governor. So basically the courts are just starting to open up. I think Alameda County is starting back on jury trials. So you need to check your local ordinance. The state with their judicial council and the executive orders has allowed local jurisdictions to make rules. In the past, this was a state purview. So check your local. All right, so the judicial council is in effect 90 days out, suspends the issues of summons, prevents entries of default judgments, and it also delays all unlawful detainer trials. Lastly, I wanted to talk about was Senate Bill 939. This is Scott Wiener and Lena Gonzalez, and there's been multiple amendments. And we expect a hearing today, and we expect more amendments. So it's being heard today in one of the hearings. But basically what this would do would prohibit commercial evictions until 90 days after the state of emergency is lifted. You have to show hardship. It forces a 12-month repayment plan, and late fees cannot be assessed. But it also opens a path for small businesses to renegotiate leases or terminate leases with no penalty. So there's some other provisions like you have to pay any unpaid rent for 3 months, accrued during the state, SOE must pay all unpaid rent accrued outside of the period. We think this piece is going to be likely to be removed. It's currently in the Senate. It still needs to go over to the Assembly. So we expect more amendments today. And I know one of the big provisions that was concerned was that people expressed concern was the guarantee, the personal liability. So if I'm XYZ LLC, I rent space and my businesses is declined because of lack of business, what is my personal liability? And part of this bill would allow you to get out of personal liability. So it's still in flux. Always kind of limited in what I want to say about bills, because what do they say? You don't want to see legislation and sausage being made. And so I think there will be, it may look a lot differently by the time it heads over to the Assembly and things, they go out and look at getting votes and trying to get it across the finish line. So with that said, so we do a lot of consulting in this area. We do expert witness work, also real estate brokerage. If you need us, here's our contact information, and I will ask the participants to share their contact information at the end of this. So at this point, I'm gonna stop sharing, and I wanna go to questions, and I have a couple questions here. Based on the new social distance guidelines and COVID-19, can we talk about risk that the landlord will be liable for damages, especially as their employees, tenants come in, people come in? So where do we see liability? I know there's a lot of cleaning and social distancing. So can we talk about liability? So if the landlord's not doing everything, say the CDC practices, where do you see the liability? Richard or Myra, do you have a comment on that?
I don't know that I can speak so much to the liability for people getting sick, but what is really concerning me, particularly in office and restaurant type spaces, is who is going to be responsible for the types of modifications that may inevitably be necessary in order for these spaces to reopen. In an office building, a landlord may be responsible for HVAC maintenance, but a major upgrade that's triggered, by the tenant's occupancy level, for example, may be a cost that landlords are going to try to push through to tenants. I see a lot of fighting happening in that area as businesses reopen.
So Myra, on that, so if you're the commercial tenant and you feel you're staying in a high-rise building and you feel that your landlord is not, or the property management group is not meeting CDC guidelines or meeting basic standards or trying to, out of sight, out of mind, how would you recommend the tenant approach the landlord and say, hey, I don't think you're taking the proper precautions here? Do you have any ideas on that?
Well, I think the first thing you do have to do is look at your lease, look at the compliance with laws section, which is, at least when I negotiate, lease is a very hotly negotiated area, apart from COVID, the issue being, and this is a perfect example of the things that landlords and tenants are trying to foresee and provide for, if a major overhaul is imposed legislatively about a fix that a building needs for health and safety, who pays for it? And where that issue usually lands is that if it's a building-wide requirement applicable to all buildings of that type, it's on the landlord. And sometimes the landlord can't even pass that cost through as operating expense to tenant, although more often than not, they can proportionally. If, on the other hand, it's something specifically triggered by the tenant's type of business. So, for example, if you have a mixed-use building and there's a restaurant on the ground floor and you have to revamp your ventilation system because of that restaurant, then more likely than not, that's going to be the tenant's responsibility. So I would start by looking there and seeing whether the language favors you or the other party. And then, as I said in my presentation, it may just be a matter of taking a practical approach. Look, this is going to cost, how many hundreds of thousands of dollars? How long am I going to be here? Who else can, help absorb some of that cost and work out something on the numbers that maybe makes sense?
So Myra, if I have a single tenant building and it's silent on extra cleaning, extra janitorial, how do you handle that?
Well, single tenant buildings are sort of unique because they very often are triple net. And now triple net means different things. In the industrial context, the landlord is often responsible for certain things, but usually that's limited to roof and parking lot, perhaps. So in a single tenant building, I think landlords have a far better shot of saying, hey, this is a building improvement that is necessary for your occupancy, single tenant, and you need to make it so. And then you would have, the covenant, the compliance with laws covenant in the lease to enforce. As with all things, non-monetary type defaults, if the tenant opens up and just disregards that requirement, but they're paying rent, now you're taking on a non-monetary default battle. And what are your remedies? To that point, many leases do allow landlords to step in and cure a tenant's default and then sue them for money damages. But that's, you're between a rock and a hard place as a landlord, whether you've got the money to finance a major improvement like that and then hope you can get it back from the tenant in court.
So onto that, so let's say that I have a retail establishment, it's single tenant and I'm the landlord, and let's say the tenant ignores precautions. Could I see liability from the landlord's perspective that a customer was injured or got COVID-19 and they sue me and the tenant and everybody, and what is my liability as a landlord?
Yeah, absolutely. Unfortunately, as a building owner, just by virtue of being on title, you are always at risk of liability for anything that happens at the building, whether it's a slip and fall or an injury in the premises that could be no fault of yours as the landlord. What we have in leases are the indemnification and insurance provisions to hold the landlord harmless for those types of liabilities. Now we're talking about COVID injury liabilities. I'd love to have some insurance people on a future panel to speak to that, because if it was a slip and fall or say an injury to another, an adjoining property or something of that nature, the landlord should be able to look to the tenant's insurance to hold them harmless and defend them in that lawsuit. If it's a COVID-19 injury where someone needs to be on a ventilator and then they die, I am not sure how that's going to play out with insurance claims.
And then one final follow-up question. Let's say the building, we can't do, let's say the elevator is too small, or we have physical things in the building that make it very difficult to be in compliance. Do you see any waivers for landlords or tenants operating in a space that's not conducive? Or
Yeah, it would be nice if we could see the kind of legislative common sense waivers we see, for example, with seismic modifications where it's impracticable. So I don't know where the legislature is going to head with that, but what I do potentially see there, Steve, is that when you have that kind of a situation, then you've got the classic impossibility of performance situation where a tenant could legitimately say, I am no longer able in the long term to perform this lease in compliance with laws. I, tenant, don't want to expose myself to liability from my customers and employees that they're not being kept safe, and so I am walking away from this lease. And I do foresee a lot of that happening, unfortunately.
great.
As a footnote in the bankruptcy area with respect to insurance, if the tenant has insurance for, that covers some kind of an action against it, even though it files for bankruptcy, the insurance is still valid and needs to be looked into.
So Richard, follow up on your question. So if I have an LLC, I'm a tenant, revenue's down, we're not able to make payroll and the rent and all the things that we have to do, and we need to file bankruptcy for protection. If I had to personally sign or guarantee, how's that going to work out?
If you personally sign a guarantee?
Yes.
The guarantor, as the guarantor, if the tenant in bankruptcy defaults, which is likely if it's in bankruptcy, the guarantor remains liable and does not get any protection from the fact that the tenant is in bankruptcy.
So you would say that if there could be a personal bankruptcy and a business bankruptcy coincide if there was a lot of liability there.
Yes, you see that a lot.
Okay, and then where do you see, do you see any special changes with bankruptcy during this period? Are there going to be different workout rules? So like a 13 where people are filing a plan, or, do you think that there'll be differences in the plans you see out there?
Well, I mean, all bankruptcies are different. 13 only applies to individuals, but there will be, the debt market right now is very hot. And so in this kind of an environment, if you take a company into bankruptcy and it has long-term viability and it's just having a current shortfall because of the situation, there's a good chance that you're going to be able to get some loans to finance an exit. And that's a positive development. Right now, that's terrific. But we'll have to wait and see how long the debt market remains very malleable and attractive.
Now, do you see stalking horses and other people buying assets in bankruptcy and consolidations and mergers? I mean, bankruptcy is a tool, and people buying assets out of bankruptcy and consolidation in the market. Can you opine on that?
Oh yeah, there's a huge distressed debt market. Right now, there's a luxury hotel in Los Angeles that is out to bid, and they have signed 500 NDAs to get into the data room. So there's an active market out there of people looking for bargains, for the right kind of assets.
So Myra, do you see any of the businesses that you're working with thinking about selling or merging with other businesses to consolidate and shore up their financial position?
I'm not seeing that just yet. I don't know, though, if perhaps the types of businesses that I represent aren't so much in that tier of business that would do that. I do know some of them are very seriously concerned about their long-term viability getting through this year and the years ahead.
Now, So when you're representing the tenant or the landlord, I guess you're looking at the sort of businesses that people are doing. You know, obviously I know people at Google and they seem to be just fine working at home. And then you see, you know, the bar and restaurant business just devastated. And we're not sure when those guys are coming back. So I would think that the landlord would have a different approach depending on the type of tenant and their ability. So are you seeing landlords letting bars and restaurants completely out of their lease, or, you know, can you give kind of a perspective on that?
Yeah, you know, my personal experience is it entirely depends on the particular tenant's situation. For example, I have a client who has an auto sales tenant. And during the shutdown, the owner of that business could not travel to bid on stock. He could not move cars. And my client reluctantly, but did give him a 100% rent deferral. A different building owned by the same client had a coffee roaster business with a retail component. So it had a little sit-down coffee feature, but it was mainly a roastery to supply other businesses. And that tenant did not get 100% rent deferral, even though the retail component was completely shut down. He negotiated 50% with them and repayable in a very short fuse because the lease is ending in November. And my client also did not want to concede. The tenant exercised the option, committed to stay, and roll over the rent payback into the new term. And my client said, no, you need to pay that back first because we haven't even negotiated the new rent yet. So he was very firm on that restaurant, that coffee producer tenant that he felt could not substantiate enough loss to justify being more forgiving.
And Richard, do you have any perspective? I know you have clients coming through thinking about bankruptcy. How do you counsel your clients in terms of, you know, maybe they haven't had a good experience with their landlord and renegotiating, or they're just completely insolvent? How do you counsel your clients on that?
Well, I don't recommend Chapter 11. I won't take a client into Chapter 11 unless I think I have a viable plan to get them back out. That doesn't make any sense, or unless it's too complicated and it shouldn't be done. You know, there are other issues like healthcare and patients and whatnot. So, you know, if a restaurant is out of business and, you know, they're basically shut down and they're going to walk away from a lease, I don't necessarily recommend that they file a bankruptcy unless, you know, there's a lot of creditors and people need to know that whatever assets they had are appropriately sold and under supervision. But restaurant assets are notoriously low valued. You know, you've got, you know, custom equipment and such, and, you know, there's not much of a market for most of that stuff. And so, unless, you know, and plus, you know, if a corporation basically walks away in this situation, it really, you could sue it, but there's nothing really that you can recover. The real key is whether or not the owners have guaranteed the lease. And generally, if that happens, I really counsel them to make a deal because, you know, you need to work out terms because fighting to resist a guarantee is very expensive, and all it does is add to your liability.
So you're really recommending go to the landlord, work something out, even if you're closing up shop, and
right. I mean, make it easy for the landlord to retake the premises for one thing. You know, don't engender a lot of problems and create bad will.
So you think that sometimes the commercial tenant says, fine, I'm not paying rent, I can't pay rent, take me out in a UD action, basically. And what you're saying is before you get to that step, realize that you're insolvent, you're not going to make it, and have some sort of friendly exit.
Yes, exactly. You want to cooperate, and, you know, everybody's in a bad situation. Don't make anybody else's worse.
So as we call in the resident, kind of like a cash for keys, maybe some sort of, hey, I'll walk and not create a bunch of disturbance.
Right.
Myra, do you have any comments on that?
No, I don't really think I have a whole lot to add. I think getting personal guarantees at the front end, if you can, is always a good strategy to keep tenants honest and keep your obligation front and center, because it's, as Richard said, a lot easier to walk away from a corporate obligation than file personal bankruptcy, which is going to affect you personally a lot more deeply. Also, as Richard said, get letters of credit. I'm trying to get a half a year's letter of credit on a lease right now. And, you know, having access to cash is your best offense as a landlord when there's a default coming down the road.
Right. So I have one question here. It says the only issue that the landlord is usually sues the owners of the corporation as alter egos and make them spend money to defend, even without a personal guarantee. So can we talk about alter egos?
Yeah, you know, I'm not a litigator, so I don't want to talk out of turn, but from what I've witnessed, I don't see landlords suing individuals willy-nilly. There has to be some crossing of the line to try and embroil individuals in a lawsuit, some way in which either the corporation was misrepresented or actions they took were, I don't know, personally bad acts. So yeah, my personal experience is not that. But again, I'm not really in that space, so I don't want to contradict the questioner.
Yeah, I see it occasionally, but in bankruptcy, it's probable, not a sure thing, but probable that the cause of action belongs to the bankruptcy trustee. And so you as the landlord, you don't necessarily get to control that. You might be able to buy it from the trustee under something like that, but then you're just buying a ticket to litigation, and it's hard fought and difficult to land. I have to apologize. I have to go to a bankruptcy court hearing right now, and I'm going to jump. Thank you.
All right. Thank you, Richard.
Thanks, Richard.
Actually, thank you, Myra, for joining us, and we appreciate that. If you have further questions, Myra, can you give us your contact information?
Yes, I'm going to try once again to share my screen if I can. Here it is. Can you see that? Can you all see that?
Yeah, I can see it, yes.
Okay, so there's my address, phone, email. Feel free to reach out.
And Myra, I want to give you a plug. You did a interesting loan for me. I don't know if you remember this, where I actually gave a loan of somebody's 50% interest in their building. So they paid,
I remember I helped you out with something. Yeah.
It all worked out, but you wrote the note, and we actually got title insurance for giving a 50% somebody their 50% interest in their property. So thank you for that. And
I'm always thrilled to hear when loans work out.
it did work out. This guy needed some cash, and it was a short-term.
Great.
So thank you for joining us, and please reach out to Myra, and she can help you have practical guidance towards dealing with a difficult situation. So, you know, I do expert witness work, and sometimes, you know, a little common sense and meeting on the minds is a lot cheaper than duking out litigation-wise. So thank you for joining us. And at this point, I will turn the presentation back over to our host, Terry. All right, stay safe. And we'll see you next time, and keep reading the emails, and we'll go from there. So Helen, do you want to take back over, or I guess this is actually the end of the presentation. So thank you, everybody, and we'll see you next time.
Thanks, Steve.